We are recording.
Okay, thank you. Welcome to the Appellate Court morning session, March 9th, 2021. This hearing is virtual using the Teams platform. It is also being live streamed on YouTube. Please be aware, to the extent the appeal involves any protected information, protected identifying information, it should not be disclosed. I'm not so sure this one does, but just as a reminder. I would ask that everyone participating in this hearing, which is FRANTZEN v. Davenport Electric, and more specifically counsel thereof, identify themselves, starting with the judges, then counsel for the appellant, finally counsel for the appellee. I am Judge Alvord.
I'm Judge Prescott. And I'm Judge Suarez.
Good morning, Your Honor. Zach Phillips for the appellant, and with me today is David Cohen.
Andrew Knott for the appellee, Your Honor. Good morning.
Okay, thank you very much. Counsel, you've received procedural instructions regarding this remote hearing. Do you have any questions about those instructions before we begin?
No, Your Honor.
Okay, one little reminder is please try and mute when you're not speaking. We will try and do the same to reduce background noise. We'll now hear from the appellant, and please let me know, Attorney Phillips, if you would like some time for rebuttal to be reserved.
Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Okay. All right.
Your Honor. May it please the court, this appeal arises from a formal hearing before the Workers' Compensation Commission on the issue of how to properly divide the attorney's fees between the parties to this appeal. Wofsy Rosen appeared at that hearing, put on extensive evidence concerning their accomplishments and their work on behalf of the claimant. On the other hand, Attorney Vaccaro chose not to appear at the hearing, not to put on any evidence, not to cross-examine witnesses, and not to substantiate his purported scheduling conflict. Based on the evidence in the record, the commissioner properly divided the attorney's fees evenly between the parties to this appeal. The decision by the board, which vacated and remanded, was improper for 3 reasons. First, the commissioner's decision to split the attorney's fees evenly was supported by sufficient evidence in the record. Second, the commissioner's decision to deny the continuance request was again supported by the record and based on a well-reasoned evaluation of the appropriate factors. And third, the board's decision and the rule advocated for by Vaccaro would set a dangerous precedent that would allow parties to boycott hearings and trials and then later appeal based on insufficient evidence because they didn't put anything on. So for those 3 reasons, this court should reverse the decision of the board and remand with instructions to affirm the decision of the commissioner. Now, on the first issue, that the commissioner's decision was supported by sufficient evidence in the record, I think it's important before getting into that evidence to just look at what the correct legal standard is, because I think that's where the board messed up in this case. The commissioner here was the trier of fact and had broad discretion both to find facts and to draw conclusions and inferences from those facts. And those factual findings are binding on the board and on this court as long as there is evidence in the record to support them. And likewise, the conclusions drawn from those facts are afforded broad discretion as long as they're not unreasonably or unlawfully drawn from the facts that are found. And so an appeal to the board is not a de novo hearing of those facts. The board standard of review, which is set forth in section 31-301-8 of the regulations, is that the board has to determine whether there is any evidence to support the commissioner's decision. And so the board can't overrule the commissioner unless there's no evidence in the record to support the decision. And this court's role is similar. It looks at whether the board correctly applied the law. And to do that in a case like this, this court looks at whether the commissioner's decision was supported by evidence in the record. And if it was, then the board erred in reversing the commissioner or vacating the commissioner's decision. And so looking at the facts in this case and the evidence that was put on, Wofsy Rosen at the hearing put on extensive evidence concerning the work that Wofsy Rosen performed and the accomplishments that Wofsy Rosen accomplished for the claimant. So Wofsy Rosen transformed this case from one non-paying claim to 3 paying claims, put on evidence that they got the insurance carriers to pay for medical treatment for permanencies, that these claims were heavily contested. Wofsy Rosen worked with doctors and experts to establish compensability and the extent of the injuries, and devoted significant time and resources for the claimant. And that was further evidenced by contemporaneous time records that were submitted as an exhibit. Wofsy Rosen put on testimony as well on all of these issues. And I think it's worth noting that at the first hearing in this case, Wofsy Rosen put on substantially the same evidence, actually a little bit more in the second hearing. And this court on appeal from the first hearing, looking at the record, said that Wofsy Rosen provided substantial evidence regarding its representation of the claimant. So I think it's unquestionable here that there was significant evidence in the record. That the commissioner also took administrative notice of the file, which showed the period of time each attorney was representing the claimant, the things that happened during those years. It showed that the attorneys represented the claimant for approximately the same amount of time. And so the commissioner's decision here to award Wofsy Rosen 50% of the fees was supported by evidence in the record. And the board erred when it vacated on the grounds that it didn't believe that the evidence garnered at this hearing formed a sufficient basis to affirm the decision. That was the stated ground from the board as to why it was vacating the decision. But the board didn't even address the actual evidence in the record. They didn't grapple with whether it was sufficient or not. The board didn't explain what about the evidence that was submitted was insufficient, or which findings or conclusions were not supported by evidence. Instead, the board just concluded that there could have been more evidence had Attorney Vaccaro shown up, or had he been given yet another opportunity. Yes, Your Honor.
Attorney Phillips, one way to look at maybe what the board's concern was that this was essentially a decision about, there was a set amount of attorney's fees. And the question was, how are we going to split them between Wofsy Rosen and Mr. Vaccaro, correct?
Correct, Your Honor.
Right, and the board, the commissioner had evidence at the hearing that Mr. Vaccaro did not participate in as to the amount of hours that Wofsy Rosen spent on the case. Agreed? Yes,
Your Honor.
But it's kind of missing the other half of the formula, right? It's hard to know what percentage of the time, total time work spent on the case is attributable to Wofsy Rosen versus Attorney Vaccaro, because we didn't have the other kind of half of that, which is how much time did Mr. Vaccaro spend on the case?
Well, I think, Your Honor, 2 points to that. One is Attorney Vaccaro had the opportunity to put that evidence in the record, and he waived that opportunity.
No, I get that. I get that. That's clear. And even the board kind of conceded that he hadn't come up with a justified reason for not being there or being entitled to the continuance. But I think the board was concerned that in the absence of any evidence as to the amount of time that Mr. Vaccaro spent on the case, how do you come up with this 50% number?
Well, I think you have to look at all of the evidence before the commissioner, which included the evidence from Wofsy Rosen, but also was she took administrative notice of the file and was familiar with the case. I mean, this case had been going on for almost 20 years at this point, and there was evidence the commissioner put in her decision that the time frame during which each attorney represented the claimant. She was aware that Attorney Vaccaro represented him for approximately the same amount of time, about 7 years, that he was the attorney when the case was resolved. And so I think from those facts that were before the commissioner, she properly drew conclusions and inferences that it should be split evenly between the two law firms here, that Lofsy Rosen represented the claimant for 6 or 7 years, got these cases started, got them into paying claims, transferred it from 1 to 3. And then about halfway through, Attorney Vaccaro took over and brought it to conclusion and represented him for about the same amount of time. And so when one of the parties has waived the right to put on evidence, I think the commissioner is still able to draw inferences and conclusions from the evidence before her that the attorneys here put on approximately the same amount of work in this case and should split the attorney's fees evenly. And it's not, the division of the attorney's fees is not just a formula based on the number of hours performed by the attorneys. It includes, the accomplishments, the value of the services, and the value to the claimant. And so from that and what was accomplished for the claimant by both attorneys, it was proper for the commissioner to split the fees based on those facts. Attorney Vaccaro has had the opportunity to put on these time records. He's never claimed that he had any contemporaneous time records. And so there's no evidence that a remand here is going to provide any more evidence or why Attorney Vaccaro couldn't refuse to show up at the next one, and how this issue could ever be resolved if the evidence before the commissioner this time was not enough. It could be delayed forever. And so for those reasons, the board's decision here to vacate the commissioner's findings when there was evidence in the record to support it. And again, the standard is there any evidence? And here there is. It's not whether it's the most evidence we could ever have or whether we wish, someone would have shown up and put on more. It's whether there's any evidence. And in this case, there was evidence to support all aspects of the commissioner's decision. Now, on the second issue, the commissioner's decision to deny Attorney Vaccaro's continuance request was supported by the record and based on appropriate factors that courts have allowed trial commissioners to consider. So trial commissioners have broad discretion when ruling on continuance requests, and they're responsible for various, institutional interests and interests for the parties in terms of avoiding delay, interruptions, managing the docket. And those were certainly at play here. But this court and the Supreme Court have also expressly endorsed other factors that trial courts and trial commissioners can consider. And the two that are relevant here that the trial commissioner considered were the legitimacy of the proffered reasons and the untimeliness of the request.
Attorney Phillips, I wonder if you're charging through an open door on this issue. I mean, the board said, we are not persuaded that the commissioner's decision to proceed with a formal hearing constituted error in and of itself, and they recognize that it's well settled that the decision to grant or deny the continuance lies within the commissioner's discretion.
I agree, Your Honor, and I agree with those statements from the board. They also say in that same paragraph that they don't think his claim was meritorious on that issue, but then, their stated justification as to why they didn't think there was enough evidence is that the commissioner could have continued it to get more evidence. And I think to the extent that that was based on their disagreement with denying the continuance request, that was an error. It's not clear to me that that played no role in the board's decision based on their stated justification.
So you've raised this claim as of error as kind of an abundance of caution. Should we kind of believe that the decision should be interpreted as overturning the commissioner on the continuance issue itself?
Yes, Your Honor, out of an abundance of caution, and to the extent that they're saying that the commissioner should have continued it to get more evidence, that was an error, that the commissioner had the discretion based on the illegitimate reason proffered by Attorney Vaccaro and the untimeliness of the request. And so my last point that I want to discuss is just that the precedent set by the board and the rule that Attorney Vaccaro is advocating for sets a dangerous precedent that allows litigants to abandon hearings, refuse to put on evidence, and then later appeal a result they don't like based on a claim that there could have been more evidence put on if they had shown up, if they had gotten a continuance. And it's not an appropriate rule. It's a strategy that has been rejected repeatedly by the appellate courts in this state, and it should be rejected again here today. And so for those three reasons, the board's decision was improper, and this court should reverse it and remand with instructions to affirm the commissioner. And if your honors don't have any further questions, I'll reserve the rest of my time for rebuttal.
Thank you, Attorney Phillips. You do have 5 full minutes for rebuttal. Attorney Knott.
Thank you, Your Honor. May it please the court. Ultimately, this matter comes down to one issue. Did the CRB substitute the judgment of the commissioner, or did the CRB essentially articulate and enforce its decision in what we refer to as FRANTZEN 1? I've addressed all of those in my brief, Your Honor. I don't really have anything to add unless the court has questions.
So,
Attorney Knott.
go ahead, Attorney.
Attorney Knott, I have one simple question that begs an answer.
Yes.
Has your client ever, or have you ever once produced competent records of how much time was spent on this matter by your firm?
I did. I was brought in only for the appeal, Your Honor, and
that's not going to be the answer because, of course, being brought in for the appeal, you've looked at everything closely that happened below. So please answer my question.
So, Your Honor, I have not produced anything. My understanding based on the record is Attorney Vaccaro has not produced anything.
Okay. So you've neither shown up nor produced anything.
That is correct.
Is that a correct statement?
Well, my client has, Your Honor, yes.
Well, that would be you, your client, you. I mean, your client's a lawyer. Isn't your client a lawyer admitted to practice in Connecticut?
He is, Your Honor, yes.
Okay. So he has never come to a hearing and never produced any evidence with respect to the time he has spent on this matter, correct?
That is correct, Your Honor.
And your position is he should be given, if we go through FRANTZEN 1, 2, and 3, a 4th bite at this apple.
I don't see it as a 4th bite at the apple, Your Honor, but what I am suggesting is that ultimately the CRB wanted to hear him, and they stated their reasons why.
Well, the CRB didn't need to hear him because they are not the trial arbiters in this matter. It's the commissioner.
Fair enough that I misspoke, Your Honor. They wanted the commissioner, the fact finder, to hear him.
And how would that be effectuated if he's never once shown up, albeit as an attorney, commissioner of the Superior Court in Connecticut, and never once produced evidence as to the time he spent on this matter?
Well, obviously, he's supposed to show up to a hearing, and I can't speak to the fact that there was a hearing and counsel did not show up.
More than
what
one.
I can't say, Your Honor. I'm sorry, Your Honor.
I believe there was more than one hearing. Am I miscounting the hearings that he didn't show up at?
I'm only referring to the one hearing at the commissioner level at which the CRB issued its decision, Your Honor.
Okay. Was he at the CRB hearing? Was he at the appeal?
I believe he was, Your Honor.
Okay. Thank you. I think it's your turn, Judge Prescott. Sorry.
So Attorney Knott, do you do any plaintiff's work?
Some in the estate matter, yes.
Okay, so you have a case where you're representing a client, and you brought an action, and the defendant has failed to appear or plead, gets defaulted, it goes to a hearing in damages and they don't show up, and you put on evidence of the damages, liabilities conceded, you put on evidence of the damages, and all of a sudden after that, the defendant brings an appeal and says there wasn't enough evidence to render a decision on damages. And if the appellate court said, you know what, you're right, we didn't hear from the other side, we need to send it back, would that make sense to you in representing your client?
No, it would not, but I see that there's a difference in the court's hypothetical versus what we have here, Your Honor.
What's the difference?
The distinction is that we have the FRANTZEN 1 CRB decision that said we wanted to hear more, and then.
But then Mr. Vaccaro doesn't show up. He had his opportunity to say more, and for the commissioner to hear more, and he washed his hands of it.
I understand what the court's asking, Your Honor, and then I stand by. The CRB essentially said we wanted to hear more, and they quoted their previous decision. I see this as an articulation and an enforcement of its previous decision, Your Honor. It's either that or a substitutive judgment, one of the two.
So as long as Mr. Vaccaro continues not to show up for a hearing in front of the commissioner on the fees that of some portion of which Wolfsey Rosen is entitled to, the commissioner can award fees because they haven't satisfied the CRB's desire to hear from Mr. Vaccaro.
I think that takes it to an absurd extreme, Your Honor, and I understand the court's point. I do believe that there is an end to this, and the CRB said they want to hear more. What the absolute end of the process is, I don't have an answer for, but I do think that the court wanted more process, or I'm sorry, the CRB wanted more process in this situation.
But I thought the CRB wanted more process because there may have been a misunderstanding of what that original formal hearing was about, whether it was with the subject matter jurisdiction or the fees. But the notice that went out on page A32 of the appellant's brief specifically states that the issue was approval of fees and expenses. So clearly had noticed that at that second hearing was with respect to the fees and expenses, right?
Yes, Your Honor.
Are you
And
suggesting?
that's the hearing that he didn't show up for.
That's correct, Your Honor.
Are you suggesting, since the commissioner seems to be out of routine tools in her toolbox to get your client to attend a hearing, that she is justified in using perhaps a less routine tool, but one that's commonly used, for example, in child support court, which is that she can order a capias and have your client picked up and brought to court?
To the extent that the CRB has that authority, I think that is something that is within the.
That's not the CRB. You misunderstood me.
I'm sorry, the commissioner.
The CRB is not the trier here. The CRB is us. It's the appellate level. The commissioner, right? I'm asking you about what tool is in her toolbox to get your client to show up. And it seems to me a capias ordered for his arrest, pick up by the marshals, put in lockup somewhere. Maybe she'd have to hold this hearing someplace that has a lockup, and bringing him in would be appropriate. Is that what you're suggesting is appropriate to get him to come to court?
I'm not. My answer is the same as before, except with commissioner, as I misspoke. Forgive me, Your Honor. But the answer is, if it's within the ambit of the authority of the commissioner to do, then I'm not saying it's appropriate. I'm saying that is within their quiver.
Is it within the ambit or the quiver, as you say, of the commissioner to do that? It would be within the quiver of a superior court judge.
Clearly, I don't have the answer to onto the law of that point, Your Honor.
So you're back to what Judge Prescott asked, or we're back to full circle, which is your client can continue not to show up.
Clearly there has to be a limit to it.
And what is that limit?
All I can answer with respect to that, Your Honor, is that according to the CRB, the limit hasn't been reached. It appears that they want to at least see some documentation and hear from him. And I don't, whether that's ordering him to show up, whether that's ordering the documents to be produced, whether that's issuing a capias, I don't have the answer, Your Honor. But clearly, the CRB indicated that what was provided was not enough. Unless the court has further questions, Your Honor, I have nothing further to add.
Okay, Attorney Phillips.
Thank you, Your Honor. I'll be brief. Just on that last point, I mean, Attorney Vaccaro is an attorney. He has a duty to show up and put on evidence in his case. You know, whether the commissioner could have had him arrested to come in, I think is not really the standard here. He is a party. Parties have to appear at hearings and put on their own evidence. And if they don't do that, they've waived their right to contest those issues, to put on evidence. And, you know, the answer to the question is he should have shown up on his own. He should have shown up and put on evidence. There's no need for the commissioner to, you know, force him in some other way to show up. She gave him notice. He chose not to show up. And that should be the end. That is where the end of this case is. And this court should end this case now by reversing the board and affirming the trial commissioner. Thank you, Your Honor.
Okay, thank you both for responding to our spirited questions. We will now conclude the third hearing of this morning.